arose out of the same conduct, transaction, or occurrence. First one is a plaintiff seeks to amend their complaint to add a new claim after the statute of limitations has expired and after the period for amendment as a matter of right, meaning 15A, so after that time frame. Second, a party seeks to leave to amend to join a new party, right, or change an existing party's name, again, after the statute of limitations has run out. So the issue of whether the parties will be able to amend their pleadings in those two scenarios is what we call the concept, again, of relation back. Means that if the rules in 15C have been satisfied, the new amended pleading will be treated as though it were filed in an earlier timely manner. So it's kind of like literally going back in time, which is interesting. To satisfy Rule 15C, you will be deemed to have related your new pleading back to your old pleading, and so your claim will not be barred by the statute of limitations. Part of my thoughts with this is, what's the point of having a statute of limitations if you're going to allow me to do a relation back, right? What's the point of me doing that? Rule 15CA1, I have up here a new claim. The first relation back rule is contained. The first one deals with a new claim. It provides, again, that if the applicable statute of limitations allows relation back between the old pleading and the proposed amended pleading, then the amended will be permissible, the amendment. When it says that the statute of limitations so requires, statutes, when they're created, whatever type of law it is, they will stay explicitly in the statute whether or not they allow relation back. Some statutes do allow it, some don't. So that's why it says if the statute of limitation allows relation back. And then second, if you're trying to do a new claim, you need to remember that Rule 15A1B provides that relation back is permitted if the amended pleading, and this is very important, arose out of the same conduct, transaction, or occurrence. We call that the same transaction or occurrence test, okay? So that's what you're looking for. Did it arise out of the same car accident? Did it arise, this new claim that you want to add, out of the same contract deal? Did it arise out of the same act of negligence? So that's very important. So it's called the same transaction and occurrence test, but that's what you're looking for, the same. And I'll later on give you more details of what you look for in that test, more elements, okay? And so let's go ahead and try this. Well, we'll do this one really quick. So Rule 15C1C is also relevant. That's, again, if you want to change a party's name in an original lawsuit. This addresses a much more difficult situation. It's one thing to add a new claim, but a new party? Like, wait a minute. So it applies when a plaintiff seeks to add a new party or change the name of an existing party. And essentially you need three things. One, again, the claim has to arise out of the same conduct or transaction as stated in the original complaint. Two, it has to be done within 120 days. So it has to be done within 120 days after filing the original complaint. And then three, it has to be within the same period, 120-day period. The defendant knew or should have known that the action should have been brought against it, but for a mistake considering the proper party's identity. So there was somebody who filed a lawsuit against my brother for an unpaid bill that he had in civil court, and they accidentally made the complaint to Otis Evans Sr. when it was Otis Evans Jr., my brother. So they made it to my dad. My brother thought it was funny, so he's like, I'm not saying anything, right? He was like 23. He's always getting in trouble in that little time frame. And yes.
I'm sorry. Is it 120 days or 90 days?
It's 90. I mean, 120. Well, 120 is different. So let me clarify. So keep the 90 days. The 90 days is correct. Wait, this is 15C1C12. 90 days. And I apologize for saying 120. All right. Where was I? Oh, so they made it to Otis Evans Sr. and it should have been Otis Evans Jr. So that's a change, it matters, you're bringing the lawsuit against the wrong person. The Moore case is kind of short, so I kind of really want to get through it. So let's do Moore case. Moore. Go ahead.
So Judith Moore went to Dr. Baker about a blockage in her carotid artery.
Okay.
The recommended surgery. Moore signed a consent form. She was severely disabled from the surgery and sued Dr. Baker.
Okay.
Her initial complaint was that he violated Georgia's informed consent law by failing to advise her of an alternative therapy. August 6, 1991, after Baker filed a motion for summary judgment on the issue of informed consent, or that date, he did that, and then on the 26th, August 26, 1990.
Okay.
Let me look at this again, make sure I have it right. August 26, 1991, Moore moved to amend her complaint to assert allegations of negligence by Dr. Baker in the performance of the surgery and his post-operative care.
Excellent and excellent. So, in this Moore case, we have, we know that Moore signed the consent form. The operation went very badly. She was severely and permanently displayed, as Attorney Cantu said, and she sues Dr. Baker because she's ticked off. In her original complaint, which is what we care about, which was filed the last day permitted by the statute of limitations, alleged that Dr. Baker had violated Georgia's informed consent law, and by failing to advise her of alternative therapies that were available as opposed to cutting her, doing a surgery. What happens after the plaintiff filed that complaint? Basically, Dr. Baker filed a motion for summary judgment on the issue of consent. In August 26, 1991, Moore moved to amend the complaint to assert allegations of negligence by Dr. Baker in performing the surgery in his post-operative care. So originally, again, her complaint said, oh, he violated Georgia's informed consent law, and now she's saying, oh, I want to add another new claim altogether, which is going to be negligence. Attorney Nair, what is the district court's holding and reasoning in this case?
For the whole,
Did they deny or grant plaintiff's motion to amend?
So they denied it because the amended complaint didn't relate to the original one. So the original complaint talked about, it had allegations about actions before the surgery, and then the amended one talked about during the surgery. So they were different conducts and happened at different times.
You're saying it correctly, different? The alleged conduct happened at different stages in this process,
Yeah.
correct? Yeah, okay, so we know the district court denied the plaintiff's motion to amend her complaint on the grounds that the newly asserted claim, again, was barred by the statute of limitations. Moore appealed to the district court, and the court says that the critical issue in 15C determinations is whether the original complaint gave notice to the defendant of the claims asserted by the plaintiff. Well, no, if your original complaint is based on consent, that's not giving me notice as a defendant that I need to start creating a defense for negligence. Like, that doesn't give me proper notice, okay? The plaintiff relied very heavily in her appeal on the Asserball case. In Asserball, the original complaint alleged negligence, right, in the performance of amniocentesis on the plaintiff, resulting in injury to the unborn child. In that Asserball case as well, the statute of limitations had expired, and the plaintiff sought to, again, amend the complaint to add a new claim that the doctor failed to obtain her informed consent prior to performing the sterilization procedure. The district court in that Asserball case that the court relies very heavily on basically said that Asserball would have any claims Asserball would have arising from the amniocentesis procedure, including a claim that the doctor should have revealed the procedure had caused a fatal injury, would have provided her with adequate notice, and therefore the amendment should have been allowed. But the court says this is very different in this particular setting. As Attorney Nair said, in Asserball, the allegations asserted in the Moore complaint, Moore versus Baker, contained nothing to put, again, Dr. Baker, as I previously stated, on notice of the new claim of negligence. There was nothing to let them know that maybe I need to start preparing a defense for this. Even the court said if you look at it, given it liberal construction, there's nothing in Moore's original complaint that would make reference to any acts of alleged negligence. The original complaint, again, focuses on the defendant's actions before the plaintiff decided, remember, informed consent, to undergo the surgery, but the amended complaint focuses on defendant's actions during and after the surgery. So Moore would have to prove a completely different set of facts with negligence as opposed to the informed consent, and that would not be fair. So they said they must conclude that Moore's new claim did not arise out of the same conduct, transaction, or occurrence as the claims in the original complaint because of that time frame. Now, some people make the argument that that's not fair because it's still part of the same. If you looked at the full opinion, the attorneys say, look, it is part of the same transaction and occurrence because the medical procedure process starts from when I go have my consult until the procedure is finished. That's all part of the same transaction occurrence. I have this ailment I'm trying to get treated, and that they didn't think it was right for the court to separate it and make that distinction. Do you agree with that it should be part of the same transaction occurrence? Should they be that nitpicky to say, well, this is pre-surgery, this was during and after? It's all part of the same incident, don't you think? No?
I agree.
I think like you said, or like it said in the case, that there are different things that the doctor's preparing for. The informed consent would be different than preparing for a negligence case. So I just think it'd be fair for him, but,
To have to be,
I think he should be on notice of what he's getting sued for.
yes, thank you.
I think that she was kind of being, she was upset that she wouldn't be successful in her informed consent. So then she tried to do the negligence. So I don't really feel like the lawyer did the due diligence at first to kind of realize, oh crap, I'm gonna fail.
Exactly.
Did this, so I'm on the doctor's side.
I like that. Anybody else? Jessica, go ahead.
Well, and also in the original complaint, they indicated that maybe everything was done reasonably and that there was no negligence. And then later they amended and tried to say that there was.
I think Jessica had her hand up.
I was just stretching.
Oh, all right. So Rule 15, what's important about Rule 15 is that it allows you to make amendments to pleadings. So if I made a mistake, I need to add a new claim, thank you so much, or a new party, when can I do that? And so relation back allows you to do it. So there's Rule 15 covers two areas. They cover, you guys both have one? Okay, I didn't know if I had enough. So they cover two areas. Thank you. They cover in that 21-day filing period where you can make a change on your own, and then after the 21 days, hopefully the opposing party will allow you to do it. Or the court will say it's in the interest of justice. If the statute of limitations has already run out, then you have the one last ditch effort, which is the relation back option of saying, you know what, we're acknowledging that even though the statute of limitations has run out, the court is going to allow you to still make that amendment if it arises out of the same transaction or occurrence. So what's important for exam purposes, I've never not tested Rule 15. So I'm guaranteeing you I'm going to test it. What I care about is that you know under what circumstances, if it's the plaintiff or the defendant, that you can make the amendment. In what time frame? Look at the dates on the test. Is it within that 21 days? I'll give you dates. I'm telling you ahead of time. And you'll decide, oh, it's within the 21 days. It's okay. Or it's not okay. I will say in the fact pattern, the statute of limitations has run out. Ding, ding, ding. So you're going to be thinking, okay, relation back. Or is it in the interest of justice? So just make sure that you understand Rule 15. I will give you hypos on that after you have a chance to let it sink in. But brutally telling you bluntly it will be on the exam, so make sure you know. All right, so let's do a flashback here. Personal jurisdiction. This is what a short answer would look like on the exam. And I'll say you can answer in 2 to 3 sentences for each one.
You said how many sentences?
I'm just giving out a number, but it'll be just a couple of sentences, okay? So you'll have a limit. So we have a lawsuit that's been filed against Katy Perry, defendant, for copyright infringement. In her affidavit, Katy claims that she has no control over the commercial distribution of Dark Horse. Her only contacts with Missouri are 4 concert performances during 2011 and 2014, which were part of international tours. Moreover, the concerts were arranged through and were services rendered by Perry to her California touring company, Katy Perry Incorporated. Defendant Perry, further avers that she has no involvement in the commercial distribution of the song anywhere, including Missouri. Dark Horse was offered for download and listening on a website accessible in Missouri. The website was owned and operated by a third party. Plaintiffs argued that the impact of the alleged copyright infringement was felt in Missouri, where 2 other plaintiff hip-hop musicians lived. First question, is this a civil or criminal case? Civil. We know it's civil because it's dealing with monetary damages. There's no criminal statute or law that has been, whatever. All right. What type of in personam jurisdiction may be possible here? So we know the defendant is Katy Perry. And where is she domiciled?
California.
All right, so Katy's in California. What about the defendant?
Missouri.
Say it louder. Missouri. All right. Okay, so what other facts do we need to know here? What cases come to mind?
The internet case.
Yeah, the sliding scale, Pavlovich, right? Is this the site where the music was? Was it downloaded? Was it a site where it was you're able to get information where they're just posting information, or was it more interactive?
Interactive.
Yeah, a little more interactive. So what does that tell us?
That she's not
It's going to establish personal jurisdiction.
Say it louder.
It's going to establish personal jurisdiction.
Okay. Where?
Missouri.
Missouri. All right. So we know Missouri. We've got the sliding scale equals personal jurisdiction. Any other types of jurisdiction might be possible here? What about in rem?
There's no property. Well, actually, no, I take that back. It's copyright infringement. Does that have any bearing on it?
You tell me.
Well, the copyright trademarks, those are considered to be like intellectual property.
Okay.
So I don't know if, I can't remember if that would count in property in terms of like in rem and quasi in rem.
What does your gut tell you?
It does.
Okay, so when in doubt on the exam, make the argument. It's not whether or not I agree with you. It's do you know the law? Make the argument that this is considered property and the dispute is about the property. It's considered intellectual property. I will give you credit. I want to know that you know the difference between in rem, using the sliding scale, right? Specific, general jurisdiction. What about what personal jurisdiction questions should be asked to determine whether Missouri may assert personal jurisdiction over Katy Perry? We asked about the website. Is it more, how interactive is it? Any other questions we should be asking? Do we care where they're incorporated? The defendant?
From what we saw, since something's on the internet, it could be anywhere at any time. So
Yeah.
it's not quite fair to go just after we're incorporated.
Absolutely. So as soon as you see an internet fact pattern, the point is you automatically apply that sliding scale. You feel like you still understand that sliding scale? If not, please review your notes. I have run out of time. I'm going to give you another fact pattern to look at and we discuss at the beginning of the next class, so hold on before you leave. Yes and no.
Did you ask about stream of
Ask Cross, yeah. Professor Cross, he teaches intellectual property. I know there's a statute that applies to that, that's outside of the They have their own set of rules for copyright.
I'm gonna look for stream of commerce.
Y'all each have one?
I have.
Okay, I have the same question. Oh, but the stream of commerce?
Yeah, I feel like I'm gonna do these over and over and over and over.